Great. So, hello everyone. Welcome to the Changes for Casuals webinar. We're really excited to have a big group of people registered to join us today for the event for Victorian Law Week 2021. So to start, I'd like to acknowledge the Wurundjeri people of the Kulin Nations, who are the traditional custodians of the land that we're presenting on today. I'm personally calling from the lands of the Wurundjeri Willen people, next to the Mary, which is the creek that I'm really grateful and lucky to be living next to. I'd also like to pay my respects to elders past, present and emerging, and add that sovereignty has never been ceded. So hello, I'm Laura. I'm a paralegal with JobWatch, and I'm just going to pass over briefly to my excellent friend Guy to say hello.
Hey everyone, my name is Guy and I am a paralegal with Morris Blackburn Lawyers, and I used to be a TIS operator, which Laura's going to have a bit more of a chat about soon at JobWatch. I was there for a bit over a year.
Great, thanks Guy. So this webinar today has been made possible through financial support from the Victorian Law Foundation, and we're really thrilled to get the chance to use this opportunity to talk about employment rights for casual workers in the context of the new changes that have come about this year. So as people probably already know, casual work accounts for an increasingly large proportion of work in Australia these days. The stats are a little bit difficult to button down, but official figures tend to land somewhere around the 20% mark. So it's really great that we can use today to speak about this matter for casual workers. So after the main bulk of the presentation today, we'll be answering some of the questions that have been submitted to us before this event. And if during the presentation any questions occur to you to ask, just drop them into the Q&A function. We have some time set aside at the end of this presentation to answer any questions you might have. So there is a chance then with that Q&A function that we might be talking about some sensitive topics that could be upsetting for people. So it could include things like discrimination, bullying at work, underpayments, or really anything that could happen to workers when they're being exploited by their employers. So if that triggers a response from you and you need to log off briefly, then we completely understand. This is also being recorded, so you'll be able to look back at the video. And if anything sort of jumps out at you as something you'd like to discuss with JobWatch, you can call us and we can try and figure out whether we can help you. So, and if it triggers an emotional response, then you can always reach out to your GP or Lifeline on 13 11 14. So just for everybody here, this is a Microsoft Teams live event. So even though you can see and hear us, me and Guy, we can't see or hear you. So, but you can still interact with us through the Q&A function, and we have our comms manager / MC for the day / extraordinaire Amanda driving the presentation in the background, so she can help with any of the technical questions you might have. And on that note, we also have closed captioning available on this webinar. So the closed captioning is auto-generated. So if there are any misspellings or mistranslations or something, and things don't make sense, just talk to Amanda and she'll try and get it sorted. Also, I think that there's also an option to have closed captioning auto-translated. And we've picked 6 languages, so Arabic, Chinese, Hindi, Portuguese, Spanish, and Urdu. So have a look at that if that piques your interest. I didn't even know the technology existed until yesterday, so that's great. We also have to add a disclaimer before we get started, just to say that what we're discussing here is general legal information and it's not legal advice. So if anything is related to your personal matter, then we do recommend that you either speak to a lawyer or call JobWatch, and we'll see what we can do. So yeah, as I mentioned, it is being recorded. So once we've uploaded this to our website at JobWatch, please do share this information with anybody who you think this will be relevant for. So that could be family or friends or whoever. So I'll tell you a little bit about JobWatch, where I work and where Guy once worked. So we're a free and confidential employment law community legal centre. So we're partly funded by the government and partly by philanthropic bodies to deliver legal assistance free of charge to people who might need that and who otherwise couldn't afford it. So we're fairly unique amongst the community legal centres who generally try and handle, a broad range of legal matters. We just specialise in employment law, so that's kind of where we're a bit unique. And we have two services that we tend to provide. So we've got the telephone information service, which is where Guy used to help out the most. And we call that affectionately TIS. And we also have our legal practice. So the TIS is free to call for people in Victoria, Queensland and Tasmania. And every year we tend to help, more than 12,000 people a year who have questions about their rights at work. So through the TIS, we tend to give legal information relevant to the individual caller. And our consultants on the other end will provide a range of legal options available to the caller. So for example, if you're calling about underpayments, then the consultant would run you through all of the different actions that you could take to recover your money. So we also run a legal practice. So that's where our lawyers tend to try and support the most vulnerable people calling through to the TIS. And we also have additional funding to provide legal assistance to particular groups. For example, last year, we got funding to provide additional legal support to people whose employment was affected by COVID-19. We also try and help people who have been dismissed through our Dismissed Workers project. And then we also have a family and domestic violence project and also an international student workers project. So these projects tend to help us with particular community groups who we've identified do need additional support. And importantly, in the context of today's presentation, we also run community legal education sessions. So we'll put together presentations about rights at work for different groups. So it could be students or migrant workers or older workers, or even different community legal centres who want an employment law refresher. So this is a really important service, as we think that it's a really great way to empower workers before issues spring up so that they're better equipped to deal with issues as they arise. And so if at the end of this presentation you found it useful and you'd like to approach us about running a presentation at your community group, then please do get in contact. So our contact details, I believe, are on the screen. So let's get stuck into the actual changes, why you've come here today. So maybe some of you saw a discussion around December last year or earlier this year in March. The government was talking about proposed changes to Australia's employment laws. So there was this big bill that was being negotiated. So it was the Fair Work Amendment supporting Australia's Job and Economic Recovery Bill. So it was, as it was initially proposed, it discussed a whole range of changes to Australia's employment laws that included things like casual work, wage theft on a federal level, simplifying modern agreements, enterprise bargaining, that sort of thing. But then in March of this year, only the proposed changes to casual work were actually passed. So that happened on the 26th this year and came into effect on the 27th. So before I get really into what the changes are about, it's worth quickly running over what casual work even is. I'm sure a lot of you do know exactly what it is, probably being casual workers yourself at some point during your employment, but I'll run through it again. So basically, unlike permanent ongoing work where a person's hours or shifts are generally set out in a verbal or written contract of employment, casual work is characterised by its flexibility. So traditionally, casual workers are employed on an as-needs basis. So essentially, casual workers aren't obligated to accept any of the shifts offered to them, but they also aren't guaranteed any hours or shifts. So casual workers also only get paid for the hours that they work. So that means that they don't get paid annual leave or personal or sick leave. And in acknowledgement of that, all casual workers are actually entitled to a 25% casual loading, which essentially means 25% more money than the base rate for part-time or full-time workers. Lastly, casual workers don't get notice periods, and they don't get redundancy pay at the end of their employment. And conversely, they don't owe any notice if they wish to end their employment. So you can probably see that whilst this type of employment can suit some people who want that higher hourly rate, or they're in a position where that kind of uncertainty as to shifts isn't really their primary concern, casual work can be stressful and confusing for other people. So, for example, where it might be beneficial is if you're a student coming into your SWAT back period with lots of exams and papers on the horizon, then you're allowed to turn down shifts in those weeks so that you can concentrate on your studies. So that could be a time when it is beneficial to be a casual worker. But we wanted to note here that whilst we mentioned that you are allowed to turn down shifts as a casual worker, we at JobWatch are very alive to the problem where there might be a workplace culture that means that if you do turn down shifts, then you won't get more shifts allocated to you. So we're aware of the reality basically for casual workers. So it's not as simple as it sounds. So, but regardless, it can be preferable to some workers especially if there's a good workplace culture. But now Guy is going to share with us a personal experience that he's had with, I guess, that sometimes meaningless option of turning down shifts that casual workers are entitled to.
Yeah, thanks, Laura. And I think it's an important thing to note that sometimes, that flexibility can be there, but in reality, it's not something that people can actually access. And one of the ways I experienced that is when I was working as an organizer for a union for suing teachers, and I'd constantly hear from suing teachers telling me that, I understand what you're saying about casual work and not having to attend every shift, but in reality, I've got to meet a 90% or an 80% attendance requirement as a casual worker. So it may be that in theory you can sort of turn down a shift willy-nilly, but I think it's important to recognise that in reality there can be some cultural pushes not to do that, or sometimes even just some straight out requirements not to miss a shift.
Thanks, Guy. Yeah. So hopefully that kind of illustrates what casual work is sort of about as we know it. But one of the big changes to casual work that has come through is that now there's actually a statutory definition of what a casual worker is. So before this statutory definition, whether a worker was a permanent or ongoing employee was determined by the courts, weighing up various factors. So it didn't really matter necessarily what the employer called the worker. What actually mattered was what the reality of the employment relationship looked like. So crucially, the courts would look at the nature of the employment over the entire period of the engagement. So they would basically be addressing the question of whether a person was employed on a regular and systematic basis with a reasonable expectation of ongoing work. If those conditions existed, they would tend to say they're more likely to be a permanent worker. So on the other hand, if a person's offered sporadic work or could turn down work if they wanted, or if they were paid a casual loading or not given annual leave, these sorts of things would tend to push the definition as being more a casual worker. So this had its problems. So it made it difficult to know with certainty whether a person was a casual or permanent worker. They could look more like a casual worker during some periods of their employment, but then in other periods they might look more like a permanent worker. And the reason why this matters is because casual workers and permanent workers have a different set of entitlements and have different obligations to their employer. So it does have a practical effect on the on the worker. So now the legislators have stepped in to change the way that the courts determine casual employment. So whilst the statutory definition, and we'll get to what they actually look like in a moment, but the new statutory definition tries to follow the court's previously used factors in weighing up casual employment. The key difference is that whether a worker is a casual worker will depend strictly on that moment of offer and acceptance of the employment. So the classification won't change after that initial moment unless a new offer of employment is made. So this means that the court can no longer look at the nature of the employment relationship as it develops over time to determine whether someone's a casual worker. So we'll quickly now look at the actual definition, which can be found in the Fair Work Act 2009. So that's our principal source of workplace rights in Australia. And the new section is section 15A for those who are interested. So as you can see, someone's a casual employee of an employer if an offer of employment made by the employer to the person is made on the basis that the employer makes no firm advance commitment to continuing and indefinite work according to an agreed pattern of work for the person, and the person accepts the offer on that basis, and the person is an employee as a result of that acceptance. So the language there is quite interesting, and the law gives the court strict guidance in determining whether there was a firm advance commitment at the start of the employer-employee relationship. So the legislators have said that the courts can only look at the following things. So I'll go through the list. Whether an employer can elect to offer work and whether the person can elect to accept or reject that work. Whether the person will work only as required according to the needs of the employer. Whether the employment is described as casual employment, and whether the person will be entitled to a casual loading or a specific rate of pay for casual employees under the terms of the offer. So essentially, the new state of affairs for casual employment means that the moment of offer and acceptance is going to determine whether you're a casual worker or not. So it's not going to be the subsequent nature of the employment after that moment. So maybe you can already see the problems with this, but as it stands, it kind of creates this strange outcome where an employer can essentially set up an offer that looks exactly like a casual offer according to the new statutory definition, but then expect the worker after that moment of acceptance to work in ways that look more like permanent work, but without the benefits of annual leave and paid sick leave. That worker would then have no recourse in court to have their work reclassified as permanent work like they used to be able to, unless they argue, of course, that there was a new agreement made for permanent work at some point during their employment. So it's a bit tricky. But they've tried to temper this issue with some new obligations to offer casuals permanent positions if certain conditions are met after 12 months. And Guy's going to explain some of those changes in more depth soon. But there's this really interesting question about whether this will essentially result in more permanent workers if employers don't end up putting in the work at the beginning of the employment relationship to make it clear that the work they're offering is casual work. We expect that these issues are probably going to be litigated pretty soon, so it's going to be an interesting one to watch. But I'll hand over now to Guy to explain some of the other changes.
Thanks, Laura. Thank you very much for that that really good explanation of what is a really tricky kind of topic with some difficult changes and difficult wording. Unfortunately, the remainder of this topic is going to be just as tricky and just as complicated, but we're going to try and break it down for you as much as possible and give you some guidance around, how to follow it and how to get how to use these new laws, I suppose, or how to apply them in your circumstances. First of all, I want to note something that might also help in this process, and that is the casual employment information sheet. So one of the changes to the legislation is a requirement now for all employers to provide casual employees with a casual employment information statement, as you can see up there on the screen. Now, hopefully this statement will make it clearer or make it easier for employees and employers to be able to understand what their rights are as a casual, and particularly what their rights are to casual conversion, which is what I'm going to talk about in a moment. So a couple of the key dates around this are if your employer is a small business or runs a small business, which means fewer than 15 people, then you should have received, and you're a casual worker, then you should have received your information statement as soon as possible after the 27th of March. So hopefully by now, but if not, hopefully pretty soon. And if your employer is any other type of employer, then you should receive that statement by as soon as possible after 27th of September of this year. Now, if it's something that you're interested in finding out on your own, or finding out about on your own, then you can have a look on the Fair Work Ombudsman's website. Amanda's going to pop a link to that, I think, in the chat section here, but otherwise you can also find it at any time by jumping on the Fair Work Ombudsman's website. So now we're going to talk about casual conversion and what that means for you as a casual employee. So I want to try and break this down as much as possible for you guys. And we're going to have a look at it in sort of 4 steps. So first of all, we're going to look at, or 3 steps, I should say. So I'm going to tell you what casual conversion is and what it takes to qualify for casual conversion. And there are 3 key points I want you to take out from that part. Then I'm going to talk about the exceptions, because lawyers and politicians all love exceptions. And there are 2 main types of exceptions I want to talk about here, which are the reasonable business grounds and the small business exceptions. If we think about those as 2 big umbrellas. And then finally, we're going to touch briefly on the way the courts can deal with disputes, where you've got complex new laws. Undoubtedly, there are going to be people that disagree. So we're going to have a look at how the courts can deal with that. And then a final note on the offsetting of entitlements at the very end. So this is probably one of the largest and most significant changes to the Fair Work Act to come out of this omnibus bill, because it makes a change to the national employment standards, and it includes the right to casual conversion, the right to be offered and the right to apply for casual conversion as a national employment standard, one of the NES. So a quick note for those of you who don't know, the national employment standards are like the bare minimum or the safety net of standards for employment in Australia. If you're employed under an enterprise agreement or an award, that award or enterprise agreement has to be better off than or as good as or better off than the national employment standards. And if you've got a common law contract or just an ordinary employment contract, then you can't contract out of these employment standards. So they really are the bare minimum. And by including the right to casual conversion in there, it really solidifies it as an important part of the employment landscape. So I'm not going to go any further into the national employment standards, but again, I believe Amanda's going to pop a link there for you to be able to have a look at your own leisure if you'd like to. All right, so back to casual conversion. So casual conversion is now considered a workplace right under the general protections provisions of the Fair Work Act, and it extends to all national system employees, so not just employees covered by an award or an enterprise agreement. The law now states that an employer must offer, so they've got a positive duty to offer an employee casual conversion if they meet if they meet 3 requirements. The first is that they've got to be employed for a period of 12 months with the employer. The second is that for the last 6 months of that period, they have to have worked a regular pattern of hours on an ongoing basis, and they can continue to do that work as a permanent employee. So these are the first 3 points I want you to remember about casual conversion. 12-month period with your employer. The last 6 months of those have to be a regular pattern of hours, and you have to be able to do that same sort of work as a permanent employee. Now, if you tick those boxes, then your employer has to make an offer or has to consider whether they make you an offer, and we'll talk about the exceptions in a minute. But for now, let's just say they have to make you an offer within 21 days after the end of that 12-month period, and then you will have 21 days to accept or reject that offer. So a few time limits there and time constraints there. And I suppose the important one to note for employees is if you don't accept it, then it's taken as a rejection. And just something to point out here as well, you know, if you think that your employer, or if you've heard of employers maybe not always doing the right thing and thinking that someone might try and change your hours or restructure your shifts, or maybe even, you know, give you the sack just to avoid these entitlements, that's not allowed under the general protections laws. So an employer can't change your hours or sack you for the purpose of avoiding having to offer you this permanent employment. Now for the exceptions. So as with everything, there are always exceptions. And the first of those, like I alluded to before, are what's known as the reasonable business grounds exception. So an employer doesn't have to make you an offer if there are reasonable business grounds based on facts that are known or reasonably foreseeable to not make that offer. So basically what that means is if your employer's got a real reason that they can think of in the future, or that exists now, or that's probably going to come up in the future, then they don't need to make you that offer, or they can decline to make you the offer. Some examples of this include where your position is going to cease to exist in the following 12-month period. So your job might be being outsourced or restructured in some way. Or it could be that the hours of work which you're going to be required to do are going to be significantly reduced. Or maybe they're not going to be reduced, but they're just going to be changed in a significant way, such that you're not going to be able to perform those hours anymore. So maybe it was, you're always working on the weekend, but there was your employer knew and knows that in the future it's going to change to a weekday requirement, and you just can't do that. As in you're not going to be able to do that because you might have a uni schedule or something like that. And lastly, the last exception here is where making an offer would not comply with a recruitment or selection process required under a state or Commonwealth law. It's a bit of a catch-all to make sure that it's not breaking any other laws. Now, just because your employer decides not to make you an offer doesn't mean they can just ignore this process. They still need to provide to you in writing the reasons why they've decided not to make that offer within the 21 days of you reaching that 12-month mark. Alrighty, so that's the first exception. The second exception is if your employer is a small business. Now, if your employer is a small business, that means they have 15 or fewer employees, then they don't have to proactively offer you casual conversion. Having said that, you can still request casual conversion. To request it, there are a few requirements here. First of all, you have to have met the eligibility criteria that I've just gone through for the other exception, for the reasonable business grounds exception. So you have to not have gone through that. Sorry, let me start again. You have to have met the eligibility criteria from the beginning. So those 3 points, the 12 months, 6 months, and pattern of work. And then you have to have not been refused, not have refused the casual conversion in the past 6 months. So you have to have not said no to your employer. And your employer has to have not given you notice that they've decided not to order the casual conversion based on reasonable business grounds. So the employer hasn't relied on that other exception before. They also have to have not refused a previous request made by you during the period. And finally, the request has to have not been made within 21 days after the employer, so your boss has put forward an offer. So there are a few more exceptions to that one, but ultimately, a few more parts to that one, but ultimately, these are the two major points of exception: whether your employer's got reasonable business grounds, or if they are a small business. Alrighty, that's a lot of changes to the Fair Work Act and a lot of things to keep track of. So just a quick reminder, the first thing that we're looking at is the the 4 steps to be able to request casual conversion, 12 months, 6 months, and then that regular pattern of hours, and being able to do so on an ongoing basis. You've got your exceptions, which are the reasonable business grounds, and then the small business exceptions. Now, what happens if you don't agree with your employer about one of these, or if you think that you've been turned down for an unfair reason? Well, there's a new avenue to resolve these through the Federal Circuit Court. Now, the Federal Circuit Court will be able to explicitly deal with disputes about whether A, you meet the requirements for your employer to make you an offer of casual conversion, or similarly, but in the reverse, you meet the requirements to make a request of your employer for casual conversion, or whether or not your employer has reasonable business grounds not to make you an offer. So whether those exceptions stand, basically. Now, this can be raised through the Federal Circuit Court. Something else to note is that the Fair Work Commission also has some capacity to deal with disputes under Section 66M of the Fair Work Act. And also these can sometimes be found under a person's enterprise agreement or under the award. Alrighty, so the last thing I'm going to touch on for this part are the offset entitlements. Again, so the ability for your employer to offset your casual loading against your entitlements to, let's say, overtime, penalty rates, etc., etc. Sorry, not overtime, annual leave. So when it comes to raising a dispute in the Fair Work Commission or around your employment, one of the most common things that we come across, or that I came across when I was at JobWatch, and I'm sure JobWatch still comes across today, is the underpayment of wages. So where your employer has withheld wages, or there's been some issue with the way that you've been employed, perhaps you've been characterized as a casual, but in actual fact you are a permanent or part-time or full-time employee, this can lead to a dispute. So the changes to the Fair Work Act now mean that where a person has been misclassified as a casual, if their employer has paid them the 25% loading, then they are able to offset that against their entitlements. So let's say you're making an underpayment claim that you should have been paid X number of dollars worth of annual leave and sick leave and potentially other entitlements. Now, the court must reduce the amount payable by the amount of loading that you would have received over that period of time. So it's a bit of an offsetting or a balancing act with I suppose the government or the parliament is trying to go through a balancing act to balance out the loading that you have received as a casual, as opposed to what you would have received if you were a permanent employee. So I might go through a quick example of this because I realize that this can be a bit confusing to understand. So I'm going to use the illustration of Sam. So let's say that Sam was working as a receptionist at a hotel for a year, and Sam was being paid as a casual. He was let go during COVID, and he's now put in a court claim asking for his entitlements to be paid as part-time rather than as a casual. In his claim, he says he has been misclassified as a casual, and as a part-timer, he's actually owed $10,000 worth of annual leave, payment in lieu of notice of termination, and redundancy pay. So under this new legislation, sure, a court can say, yep, Sam, we agree that you were misclassified and you should have been a part-timer instead of a casual. However, you did receive the 25% loading as a casual. And so we're going to take this into account when we're doing the calculations. And in the end, you're going to get paid $7,000 worth of entitlements instead of the $10,000 worth of entitlements that you would have otherwise been entitled to. So it's just essentially taking away, I suppose, or taking into account what's already been provided to Sam, which is that 25%, and then offsetting that against what else the additional amount or entitlements that he should have received. So again, here, this is a major change to the Fair Work Act, and we expect that this is going to be litigated in the courts, and that'll potentially change the way that we see this, or the way that we see this provision applied going into the future. So that'll be something interesting to keep a note of. Alrighty, now here is an important date to keep in mind if you're currently a casual employee. If you're already working casually for an employer that isn't a small business, then your employer needs to assess by the 27th of September whether you and other casual employees are entitled to be offered casual conversion based on what the work you've done already. So, you know, as much as this new change is going to look forward for new casuals, there's also a requirement to look back and see, you know, whether the casual employees at the moment should be offered this casual conversion. If you believe that you're eligible but you haven't heard from your employer, then you can also make a request in writing yourself. All right, I realise that was a lot of information, a lot of really legal and technical things here. I think we might have a bit of time for maybe one or two examples, and then we'll jump into some Q&A. That might be the best way to go about it, just keeping an eye on the time. So I might run through one more example. Let me just have a quick look here and see which one is the best one, and then we'll jump into your questions and hopefully have some time to answer some live ones here today as well. Alrighty. So I might run through a quick example of George. George has been working at Bunnings Garden Centre for the past 18 months. He actually retired 2 years ago, but chose to go back to work casually because he missed interacting with the public. He's offered the opportunity to convert his employment by Bunnings before the deadline of the 27th of September, but he chooses to turn it down because he prefers the flexibility, being able to pick and choose his shifts. This is a good example of someone who wants to just remain as a casual. Alternatively, if you look at someone like Michael's been a casual checkout operator at Coles for 18 months, and he's offered the opportunity to convert. He confirms that he accepts the offer of casual conversion, and now he has guaranteed shifts every week. He's got a guaranteed income, and he's able to, you know, plan for things for the future, plan for that holiday maybe, and also he knows that if he needs to take some time off because he's sick, he's not going to miss out on any pay. Alrighty, we might leave it there with the questions or with the examples and jump into some questions. So we have received some questions in advance, so we're going to go through a few of those now. I might and I can see that there are some questions in the Q&A as well, so thank you for popping those in. We'll do our best to touch on these if we can now, otherwise maybe we'll send something out afterwards. But I might hand it back to Laura now to go through the first question.
All right. Thank you so much, Guy. You did such an excellent job summarizing what is a very, you know, extreme and sometimes confusing changes to casual work now. So thank you for that. Now, what I might do is, Amanda, if you want to jump on and just ask, oh no, sorry, what I'll do is I'll run through the questions that we've already had submitted. So just give me a second. So the first question that we've received is one that I'll take on. So the first question is, how did the changes to the casual to permanent laws impact those engaged via a recruitment agency / labour hire company? And I actually have seen that there's potentially a relevant question that was submitted in the Q&A here. So basically, there's a difference between recruitment agency and labour hire companies first to begin with, even though a lot of people use those terms interchangeably. But the important question to figure out is who is the employer? So with recruitment agencies, they're often places that try and assist you to get work. And then once you find suitable work, then you're employed by that place that you applied to. Whereas labour hire companies hire you themselves, so you are the employee of the labour hire company, and they contract you out to a different company that you might be working with. So the employer in the first scenario is the company that you apply for, and the employer in the second scenario with the labour hire company is the labour hire company, and you're not the employee of the host company, is what we call them. So the simple answer to this is that whoever the employer is will be obligated to follow the new changes. So yeah, all of the changes to the casual work will apply to the employer. So the next question, and I'll ask it, and then maybe Guy can respond to it. Thanks, Guy. So the next question is, I've been a casual contractor for a government department for 18 months. The agency is technically my employer, and I've asked them if my rights will change as a result of the new legislation, and they've told me that that was between me and my department. Do I have a right to convert to permanent, and who will be in control of that decision?
Alrighty, so this one follows on in a similar vein to the last question. I think the first step for this person is to probably give JobWatch a call to dive into this situation a little bit more, and to sort of flesh out flesh it out a bit more, and then potentially even look at getting some legal advice after that if it's necessary. But looking at this broadly, the first point of call is that you can't be a casual contractor. So you're either a casual employee or you're an independent contractor. Now, if you're a casual employee, then the answer is the same as the previous question. That obligation rests with your employer. So if you're employed by an agency, then that obligation rests with the agency, which is separate to potentially to the government or to the government body. So assuming that your employer has more than 15 employees, then like we went through with the previous two examples, they need to make that offer to you, or they need to at least consider they need to consider whether you are entitled to, whether you should be a permanent employee or offered permanent employment by the 27th of September. And equally, if they don't make that offer to you, then you can also request that and request it in writing if you believe that you're entitled to it. Now, if you're an independent contractor, then these provisions don't apply. These provisions apply to someone who's an employee. If you're not sure whether you are an independent contractor or an employee, again, this is probably a point where you'd want to give JobWatch a call for some more information, or potentially refer to some legal advice, because there are ultimately a number of indicia, or a number of sort of requirements, or actually they're not requirements, a number of indicators that a person is a casual employee, is an employee as opposed to an independent contractor. Some of the signs, or some of these indicators, are you provide your own tools and equipment, you've got a great degree of control over the work that you do, you can turn down work, you can work for multiple different contractors, people that contract you out, and you can turn down work, you can get someone else to do your work for you, you generally have an ABN, got to pay your own taxes as opposed to having them taken out of your income, generally don't get super. So the reason I correct myself around these being requirements is that you don't need to tick all the boxes, and the court really does weigh up weigh up all of these considerations, and sometimes you can just tick one of them, one of these indicia, and be an independent contractor, or equally you might tick a few, but ultimately you're an employee. So that's why you can see it's a bit of a tricky area, and it's probably worth having a chat with someone further about if it's a real sticking point for you. So I might ask the next question back to you, Laura. What happens if your workplace does not comply with these changes? What can we do?
All right, so we already briefly touched on it earlier. Well, Guy went through some of the avenues that you can have as this turns into a dispute. So because the new changes are actually enshrined in our our laws, so under the national employment standards, then people can apply to the Fair Work Ombudsman for assistance in applying for orders at the Federal Circuit Court for employers who don't comply with some of these new changes, or they can refer to the Fair Work Commission to deal with the dispute. So that is also set out in the new laws, as well as being contained in a lot of people's modern awards or enterprise agreements, that option to escalate disputes. Generally, it has to start at the internal level and exhaust all options at that internal level before being able to be progressed to the Fair Work Commission. So I know we keep saying this, but you really can just seek that initial legal information at JobWatch through the telephone information service first for more information that's tailored to your individual circumstances. So these are great questions. Guy, I'll ask the next one of you. So how will the small claims procedure for casual conversion requests work? Will the Federal Circuit Court have the ability in this small claims procedure to order casual employees be converted to permanent employment?
Good question. Again, like you said, lots of good questions. So the Federal Circuit Court can make any order when it comes to dealing with these matters, any order it considers appropriate, basically. Now, the examples that are given in the Act, so under Section 548 1B, are generally gentler than this, so they don't explicitly say, that they can force the conversion or order the conversion. They tend to be something like, requiring an employer to consider whether an offer should be made. But ultimately, yes, it is, the power is, or the court does have the ability to make those sort of orders. Alrighty. So what happens, Laura, if you've just in April this year requested to convert your casual regular hours to permanent part-time, and your employer rejects it with the only reason given being a clause, sorry, read this again, where the only reason given was a clause was struck out of the enterprise agreement for casual conversion. So the enterprise agreement didn't have the clause, or had the clause struck out.
Yeah, and I suppose with this question, it matters, the timing actually matters when the request was made. So if this request was made before the changes actually came into effect, then and the person didn't have the right under the new changes or under the enterprise agreement to make that request, then the employer has no obligation to respond positively. However, if this request comes after the new changes, then because it's part of the national employment standards, as we described or talked about earlier, then they can't be, those national employment standards can't be undercut by the terms of the enterprise agreement. So basically, if the employer's failed under their obligations, then you can pursue it doing dispute resolution procedures or some of the enforcement options that we've talked about earlier, which includes going to the Federal Circuit Court or referring the dispute to the Fair Work Commission. So hopefully employers will do what they're meant to do, but you can never be sure. So, Guy, how can I check that I'm being paid the correct amount?
All right, so I suppose the precursor to this is how are you employed, or what is the instrument that you're employed under? So most people are either employed under an award, an enterprise agreement, or a common law, what's called a common law contract, which is a contract. Now, if you are employed under an award, then you can have a look. First of all, you could call the Fair Work Ombudsman, and they can help you, determine which award you are employed under, and then work out which level, or they'll help you work out which level that you may be classified under that. And the awards have a classification structure for their employees classified under them that sets out the rate of pay, overtime, meal allowances, all sorts of allowances and entitlements under there. So you could have a look at that award. There's also a tool on the Fair Work Ombudsman's website, which is called the PACT very good acronym. They're very good with their acronyms, which stands for the Pay and Conditions Tool. So you could find out your award, or if you already know, then jump on there and answer some questions to help you find out which level you may be classified under. If you're working under an enterprise agreement, now this tends to happen with larger companies, but also some smaller companies will have an enterprise agreement, which is an agreement between the company and the employees of that company as a collective. That will also set out your rights and entitlements, including minimum wage or your wages, overtime, etc., etc. So that's how you can check. You can check your payslip off against what's in the award or enterprise agreement. And finally, if you're working under a common law contract, then you would hopefully have that spelled out, or the rate of pay set out in your contract. So you'd have to have a look at that. Generally speaking, that needs to be as good, if not better, than what it is under an award or enterprise agreement. And I've just seen here that Amanda is also going to drop a link to that PACT tool in the announcements tab, so you can have a look there for that. All right, next question for you, Laura, is do casual employees have the right to be paid superannuation? Very important thing, especially for young people, I think. Superannuation?
Yeah, totally. So the answer is yes, they do have a right if they're over the age of 18. And so maybe some of you saw the federal budget outcome recently. So there used to be a financial threshold that you had to meet before you were paid superannuation as a casual worker, but now that's gone. So as long as you're over 18 and you're a casual worker, it doesn't matter how much you're earning, you should be getting paid super. And superannuation, so there are going to be some changes on how much superannuation actually is, but at this point, it's an additional 9.5% generally that employees are owed, and that's additional to their wages, and that's really important. Some employers will try and pretend that you're getting superannuation, but not actually pay it. Yeah, that's the short answer. So I'll quickly tell you how it's calculated though. So it's based on the ordinary time earnings, that 9.5%. So that includes your basic wages and those types of allowances and bonuses. But some things that aren't included it doesn't include overtime or reimbursements. So yeah, that's positive news, positive changes for casual workers again. So Guy, are there any vital things to look out for in employment contracts, especially for interns, such as waiving rights for injury/damage, unpaid internships, etc.? Are there lines to draw for unfair, unacceptable employment terms in a contract?
All right, so this is a big question and it could be the topic of its own webinar, but I'll do my best to highlight some of the key points here. So first of all, an internship has to be for the benefit of the intern or for the person who's undertaking the internship, and not just a part of the business's commercial operations. So for example, if it was for a credit in a university subject, and I can give a good example of how I started my time at JobWatch. I started off as a intern for doing a subject called I can't remember what it was called, but it was a practical subject anyway, and I got a credit for my first 11 weeks, I think it was, working at JobWatch. It formed part of my degree. If the relationship is in fact an employment relationship, then as an employee you would have the rights of an employee and entitlements. Generally speaking, an employment contract can't undercut the national employment standards, so those standards that we alluded to earlier. And the Fair Work Act also specifically prevents a contract from having particularly onerous or egregious sorts of terms, like unreasonable requirements to pay money, and also you can't have a contract that requires you to do something that's illegal or, you know, that it's unsafe. So ultimately, if you're the person who asked this question again, it might be worth digging into a bit more if you think that, you know, this isn't just for your benefit as a student or something like that. That it seems to be the ordinary operations of the business, and they're trying to make some money out of this situation or save some money. You know, maybe it's worth having a bit more of an investigation or inquiry into that. Now we've got a couple more questions here, but I'm just wondering whether we maybe jump to the chat, Amanda, try and maybe see if there are any live questions. Otherwise, I'm just conscious that we're getting close to 5 o'clock.
Yeah, absolutely. So we do have a couple of questions. Some of them I've responded to privately because we've been able to respond to it through our general presentation. But we do have two here. One from Paul, who has asked, what is the process if an employer, let me start again. What is the process for an employer to switch a permanent worker to a casual role? So the reverse of what we've been talking about.
Yeah, I'm happy to take that one. So basically, I mean, as an employer, you can change the employment relationship by agreement with the employee. So it does require both parties to agree. You can't change it unilaterally, or else that could result in unfair dismissal or redundancy. So it's all about just agreement between the two parties. And I mean, in the context of what we've been talking about as well, you need to be aware, I suppose, that there are additional requirements for the employer to make sure that the employment relationship is actually a casual relationship, if that's what you're interested in setting up. So making it clear at the beginning that the new role does not include a firm advance commitment, and that the work will not continue indefinitely with an agreed pattern of work. So there's a little bit more work that the employers have to do, and making it clear that they can turn down shifts is really good practice, and providing as much information and knowledge to the worker as to what they're getting into is really recommended.
Wonderful, thank you, Laura. We've got.
Could I just, sorry, just one more point to add there, is that if you are being converted to, or you think you're being converted to casual, or your employer wants to do that, it's probably worth, and you don't want to do that, it's worth jumping onto straight away, because you don't want to get into a situation where you've kind of, you know, you've just gone along with it and said, yeah, okay, I suppose this is what it is, and, you know, inadvertently accepted that change if it's not what you want. So
that's a really good point, just to note that you don't have to agree to any sort of contract variation if you don't want to. So be really cautious and take your time to decide these things. So yeah, is there another?
Yes, so we've got one more. So the person asking the question is a casual worker with irregular working patterns, and they plan to quit their job. How should they appropriately approach this?
Well, I'll go for it, guys.
Yeah. So generally speaking, obviously not knowing the particular employment situation, as any employee, you can obviously quit your job at any time as long as you meet the notice requirements under the award, enterprise agreement, or contract. So that'd be what I would be looking at. So if you're a casual employee, I believe you said, Amanda, it's worth checking with what award you're covered by and what the notice requirements are. So it might be, and generally speaking, it's not a lot. You know, for example, I know of an award which is the fitness award, which requires an hour's notice. So you know, find out what that notice period is, and then basically, as long as you've ticked those boxes, then you can let your employer know that, and then resign and move on.
Lovely. Thank you both. Now, I'm just really conscious of time. It's 5:01. We did have a few other pre-submitted questions that we were wanting to get through, but given that we've kind of already got the answers to them, we might respond to those individuals directly offline. Just mindful that, you know, if you're tuning in from work, you might want to jump on the train sooner rather than later. So we might just skip right to the conclusion, Laura and Guy.
Yeah, so thank you all so much for attending. We've given you so much information. So if there's anything that you want to chase up, we've got some relevant information sheets on the JobWatch website. So please check that out. One thing that we always like to stress is if something bad happens to you at work, such as you get dismissed or you're forced to resign or any sort of thing like that, terrible thing that happens, please don't hesitate to contact JobWatch, because there are some really strict time limits on certain things like filing an unfair dismissal claim, which only gives you 21 days to lodge something with the Fair Work Commission. So it's really just worth, I know that it can be really stressful, just jumping on the phone to JobWatch and seeing what you should do, what you should think about, whether things were, you know, above board. So please do contact JobWatch's TIS and we can give you that free confidential legal information. So a reminder that we're going to be sending out a survey to all webinar participants in the next 24 hours, and it's going to be really helpful for us if you complete that survey so we can improve in the future. So Amanda is also reminding me to follow us on social media. So on Facebook, Twitter, LinkedIn, we're trying to be a bit more active. So if you enjoyed today, please leave us a review on Facebook and Google. And thank you so much for tuning in. Hopefully you found it useful.